ladies and gentlemen of the jury, I will come to you and I will explain why I believe, and grudgingly, that the California Supreme Court was correct in its advisory opinion to the Ninth Circuit Court that the proponents of the ballot measure do have the right to defend the statute in court. Fact: Proposition 8 was passed by 52% of the vote, 48% opposed, and its prior statute was passed with 62% of the vote, 38% opposed. Proposition 22 passed with a 24-point difference. Proposition 8, 4-point difference. Proposition 8 went to court in January of 2012, or 2010. After 13 days of grueling testimony by the plaintiffs and two witnesses by the defendants, Judge Vaughn Walker on August 4th, 2010, struck down Proposition 8 as unconstitutional. Then it went to federal circuit, the circuit court, the Ninth Circuit, which covers California and California up to Washington and probably like Arizona, New Mexico, and kind of gets off at Idaho and a couple of other, maybe Nebraska. I think it falls short of Nebraska and down that way. But uncharacteristic moment, right? But the California Supreme Court had to give a question back to the California State Supreme Court. After being chided by the Supreme Court in Arizonans for Official English for not seeing if Arizona had such a law or a case that allowed ballot initiative proponents the ability to defend a law in court absent a government official or the executive branch, they chided them because that's what should have been done first. Not being one to repeat this chiding, the three-judge panel of the Ninth Circuit, Judge Reinhart, Hawkins, and Smith, they had to send an advisory question to the California Supreme Court, which would be an advisory opinion, and thus they would go in hand with the California State Supreme Court's decision. Question: does California law give the proponents of a ballot measure the ability to defend such a law when the government officials in charge of defending such laws are absent from the case? Article 3 standing is basically saying you can stand and defend the law and you have to prove harm. But being that this is such a case with a constitutional amendment that can't be vetoed by the governor or amended by the legislature, this poses a unique problem because the initiative process is a check. Unfortunately, it was used for this terrible deal, but Proposition 8 was the best thing the Mormon Church could have done because it simply exposed them for what they are and what they've been doing. However, that does not enter into the question and the California's advisory opinion. Why I believe that the California Supreme Court was right was simply because they have to protect the initiative process. They have to make sure that even if there was a contrary opinion that they ruled in May of 2008 with a 4-3 decision in the in re marriages cases, that at least the proponents of the ballot measure and the people who voted yes on this still have a voice and still have someone to defend their law. The governor cannot veto an amendment, a constitutional amendment that has been a constitutional amendment. So therefore, if the governor does not defend this law, Is he getting a pocket veto? And that is exactly the issue in this case with the standing or grounds. Can we give the governor a pocket veto because, oh, he doesn't want to defend the law, or the attorney general doesn't want to? So if we're going to say that, then that means that we are basically in effect giving him a pocket veto, and that runs contrary to the California Constitution. But if we say that you don't have standing according to the law, then the people who voted yes on this will not have a voice to at least defend their law and the merits of the case or not. So therefore, I believe with that conundrum, the California Supreme Court has to basically say, yes, the ballot proponents, the initiative proponents, do have standing to actually defend this law, because otherwise would be to disenfranchise not just the people who voted yes, but also the other side. As much as I am for equal rights of gay and lesbian persons, I do not want someone else's voice drowned out by a pocket veto with the governor. Though I believe Proposition 8 will be overturned completely, whether or not the Supreme Court takes it is another matter right now that we're waiting on. But I do believe that all voices, that the proponents' voices should be heard, and they have had all the time to make their case, and they failed at it. And they should have the opportunity to fail, big time. So that is why I grudgingly believe that the California Supreme Court was right to protect the integrity of the initiative process, but also to protect the California state constitution, which they are tasked with as judicial officials. So that's the one thing that I really feel is that standing was actually the right thing to do. And if I were on that en banc hearing, I would have to say, even though I disagree with the actual proposition, I must uphold the California state constitution and not give Governor Schwarzenegger at the time a pocket veto for a constitutional amendment that he opposes. So that is my main reason, my biggest reason, to protect the California initiative process, which I definitely think will need to be reformed a little bit, but also to uphold the California state constitution. Those delicate balances would lead me to vote yes. The ballot proponents do have standing in this case. However, the federal standing, the Article 3 standing, may be another issue. The Supreme Court can state that they do not have standing to defend this in federal court, because federal court and state court are quite different. However, the advisory opinion won't be the reason why they're denied standing in federal court or in the Supreme Court. So those are my reasons, and I believe that the California Supreme Court actually did the right thing when tasked with this interesting conundrum. Have a great day, YouTube.